XRP attorney reveals key details on the next important date on February 20, 2024. The Securities and Exchange Commission's second Ripple Labs are getting ready for a critical legal. As this is the single thing that has the potential to turn the case on its head, everyone's attention is focused on the case. Ripple is confident in its capacity to negotiate the strategies employed by the SEC to lengthen the legal process for the purpose of gaining a financial advantage. This is despite the fact that the SEC may be celebrating a prior triumph that forced it to provide financial documents. During this time, legal professionals offer some important information. An update from Falan gives weight to the 20th of February hearing James K. Falan, a well-known attorney, shared his thoughts on the significance of the 20th of February and the ongoing legal struggle between the SEC and Ripple. It is anticipated that Ripple will provide a response to the inquiries made by the SEC on this date, which will signal an important milestone in the continuing dispute. In this moment, the entire controversy is centered on the documents pertaining to the finances. The court will decide the sanctions that will be imposed on Ripple for the alleged violations of securities legislation that it is committed, notably with regard to its sales of XRP to institutional clients during the remedies phase of the action. A motion was submitted by the Securities and Exchange Commission C to demand Ripple to furnish its audited financial accounts for the years 2022 to 23, as well as contracts for sales in order to assist the court in making a decision. After the lawsuit was filed, the Securities and Exchange Commission also requested information regarding the amount of profit that Ripple made from selling XRP to large investors. In this matter, Ripple first fought, but Magistrate Sarah Netburn ultimately decided in favor of the SEC. The records that have been sought must now be provided by Ripple by the 20th of influence on the prospective XRP sales of Ripple. The forthcoming disclosure of Ripple's financial records will have a significant impact on the manner in which the court determines which measures are most appropriate. Not only may Ripple be subject to fines, but there is also the possibility that an injunction could be issued on the company's future sales of XRP to large customers. The SEC asserts that these financial data are of utmost significance in assessing whether or not an injunction of this kind is required. It is possible that Ripple will be required to register with the SEC in order to sell XRP to institutional buyers in the United States, if this is the case. What comes next? A look into the future reveals that the next key phase of the lawsuit will take place between March 13th and April 29th. During this time, after this length of time has passed, the court will decide what the appropriate punishment should be for the alleged offenses committed by Ripple. It is possible that a resolution may be reached this year, according to legal experts and Ripple's chief technology officer, David Schwartz. However, the possibility of appeals could push the process back until 2025 or 2026. Appeals that could be made in the conclusion Ripple and SEC both have the ability to contest rulings that are in disagreement. So appeals are still a possibility. Ripple benefited from the summary judgment that was issued the previous year, but the SEC continues to contest certain aspects of it. The interlocutory appeal filed by the SEC was rejected by the court, which further complicated the judicial process. Depending on the outcome of the case, the district court might consider additional appeals this year. The XRP community is getting ready for the next phase in this convoluted litigation, which might have an effect on Ripple XRP and the regulation of digital assets. The judgment is expected to be handed out on February 20. As Ripple Labs and the United States Securities and Exchange Commission SEC prepare for the next significant deadline in the lawsuit, the contentious legal battle between the two entities is heating up. The upcoming date in the lawsuit would be February 20. This is because Ripple and the SEC are currently in the remedies phase of the case, which is centered on institutional sales. In July of 2023, Ripple achieved a significant victory in the litigation. Nonetheless, the court held that certain XRP institutional sales constituted investment contracts and, as a result, should have been registered with the Securities and Exchange Commission. The time for remedies-related discovery has been extended by 1 week, from February 12, 2024 to February 20, 2024. It is important to keep in mind that Ripple made a request earlier in February to extend the deadline for remedies-related discovery by 1 week from February 12 to February 20. This should be considered the next critical deadline in the ongoing legal battle among the parties involved. In this stage of the process, the discovery phase continues to be essential because it has the potential to expose new information or arguments that could have an effect on remedy options. The Securities and Exchange Commission served 9 interrogatories and 3 requests for proposals IRF behind Ripple on November 14, a throwback to actions that occurred prior to this significant date. The SEC filed a motion on January 11 to compel discovery of Ripple's financial statements for the years 2022 and 23 post-complaint written contracts governing XRP sales to institutional buyers, hedge funds, and ODL customers, and the proceeds Ripple received for delivering XRP after the complaint was filed, but with written contracts entered into before the complaint was filed. This came after the parties met and conferred on December 21 and January 3 in an effort to narrow the dispute. Additionally, on February 5th, Judge Netburn granted the SEC's request to compel in its entirety. In the wake of Judge Netburn's judgment, Ripple said that it will deliver a response to the SEC's interrogatory regarding post-complaint proceeds from pre-complaint contracts by the prior discovery date of February 12, 2024. Additionally, the company claimed that it would release any available financial statements. Ripple, on the other hand, requested a short extension until February 20 in order to produce its contracts for the sale of XRP to institutional buyers, hedge funds, and old customers from a complicated 3-year period prior. The company cited the difficulty associated with attempting to collect and produce. In this particular instance, Ripple did not make any request to modify any of the other deadlines. Hence, these deadlines have not been altered. It is anticipated that the submission of legal briefs will take place between the months of March and April of this year. Following this, the court will make a decision regarding which remedies to provide. David Schwartz, the chief technology officer of Ripple, has clearly refuted the allegations and responded to the claims that have been made against him in response to allegations that he has manipulated the price of XRP. In order to respond to the allegations and provide clarification regarding Ripple's position on the topic, Schwartz took to X. Schwartz rejected the allegations, noting that Ripple had stopped its programmatic sales of XRP since the first quarter of 2023, as revealed in Ripple's 2023 XRP Markets report. Schwartz's statement was in response to the allegations' assertions. The position taken by Ripple's chief technology officer emphasized Ripple's commitment to reducing any price disruptions that may emerge from these sales and expressed confusion at the charges of manipulation. I do not believe that our programmatic sales of XRP manipulated the price in any circumstance. I feel that we took every effort to reduce the influence that our programmatic sales had on the prices of our product. I do not believe that the price of XRP was affected in any manner by our programmatic sales of the cryptocurrency. I feel that we took every effort to reduce the influence that our programmatic sales had on the prices of our product. I, too, find the accusation to be perplexing. What exactly is supposed to be our reason for manipulating the price with our actions? Despite the fact that Schwartz offered answers, the XR community continued to have skepticism regarding Ripple's sales techniques and the efficiency of its payment solutions.